Today we will review some of the basics of the Constitution. We will begin with Article 1, which establishes the legislative or lawmaking branch, which we call Congress. We have a bicameral system, which means that our legislative branch is two houses, the House of Representatives and the Senate. The framers of the Constitution established this bicameral system at the Constitutional Convention. There was a lot of fighting between the large and small states over how our legislative branch should work and how many representatives each state should get. The large states were represented by the delegates from Virginia, and they felt that states with higher populations should get more representatives in the legislative branch. Not wanting to be taken advantage of by the large states, the small states were represented by the delegates from New Jersey and felt that every state should have the same number of representatives. The delegates from Connecticut came up with a compromise to make both the large and small states happy. The Connecticut plan called for a two-house legislature. In the House of Representatives, representation would be based on population, with larger states getting more representatives. In the Senate, each state would get the same number of representatives, 2, regardless of that state's size. Because the fight over representation had pitted the large and small states against each other, and nearly ended the Constitutional Convention, the Connecticut Compromise is often called the Great Compromise to honor its importance. Now we will examine the House of Representatives in particular. The term of office for the House of Representatives is 2 years. To run for the House of Representatives, you must be at least 25 years old, a citizen of the United States for at least 7 years, and a resident of the state that you are running to represent. The House of Representatives has a presiding officer called the Speaker of the House, who sits before the House of Representatives and runs things. To choose the Speaker, each political party nominates a candidate, and then the entire House votes. Therefore, the Speaker usually ends up being a member of whichever political party happens to have the majority at the time. When it comes to writing bills, the House of Representatives has a special privilege. If Congress wants to write a bill that will increase taxes, it must originate or start in the House of Representatives. The framers of the Constitution planned for the House of Representatives to be closer and more accountable to their people than the Senate, and for this reason, all tax bills must begin the bill-to-law process in the House. Now we will take a look at the Senate in particular. The term of office for the Senate is 6 years. To run for the Senate, you must be at least 30 years old, a citizen of the United States for at least 9 years, and a resident of the state you are running to represent. The presiding officer of the Senate is called the President of the Senate, and the Vice President of the United States automatically gets this job. Because the Vice President is not elected as a senator, but gets this role by being elected in the presidential election, he or she may only vote in the Senate if it is needed to break a tie. Congress has more powers in the Constitution than either of the other two branches. Congress has the power to make laws, create the federal court system under the Supreme Court, declare war, coin money, raise an army and a navy, regulate commerce, which is business between two or more states, tax, spend, borrow money, establish standards for weights and measures, establish copyright laws, establish post offices, roads, etc. Together, both houses of Congress play a role in removing the president from office. The House of Representatives votes to impeach or accuse the president of a crime. The Senate holds the trial to determine if the president is guilty. The judicial branch is also involved. The Senate trial is overseen by the Chief Justice of the Supreme Court. Article 1, Section 8 gives Congress the power to make all laws necessary and proper for carrying into execution the foregoing powers, and all other powers vested by this Constitution in the government of the United States or any department thereof. This is often called the Necessary and Proper Clause or the Elastic Clause, and is important because it is seen as constitutional proof of implied powers. It allows Congress to make any law that relates to a power given to them in the Constitution, even if that law isn't stated word for word in the Constitution. The Constitution also offers Congress some protections so they may perform their lawmaking function effectively. Article 1, Section 6 reads, They, senators and representatives, shall in all cases, except treason, felony, and breach of peace, be privileged from arrest during their attendance at the session of their respective houses, and in going to and returning from the same, and for any speech or debate in either house, they shall not be questioned in any other place. This means that senators and representatives are protected from civil suits and most criminal charges while Congress is in session. A civil suit is when one individual sues another individual, while a criminal charge is when you are accused of breaking a law. This is meant to protect lawmakers from being accused of crimes merely because someone disagrees with the political decisions they are making while in office. In addition to granting them powers and protections, the Constitution also forbids Congress from making certain types of laws. Congress may not pass a law that suspends habeas corpus. Habeas corpus literally means to produce the body, but it actually refers to your right to appear before a judge after your arrest and be told which crimes you are being charged with. In other words, you cannot be held in prison for an extended amount of time without being charged with a crime. Congress may also not issue bills of attainder, which are laws that punish a person or a group of people without giving them a trial. Additionally, Congress may not write ex post facto laws, or laws that are retroactive. This means that if you performed an action in the past, and a law is passed in the present that makes that action a crime, you cannot be charged with breaking the law because your action was not a crime when you performed it. Congress is also denied the power of charging export taxes on goods sold to foreign countries. Changing topics a bit, within Article 1, states are also forbidden from doing a few things, including making treaties with foreign countries, coining money, passing ex post facto laws, or issuing bills of attainder. Moving right along, Article 2 of the Constitution outlines the executive branch, or the law enforcing branch, which mainly refers to the presidency. The president is given several powers in Article 2, including the power to grant reprieves and pardons. Reprieves delay your prison sentence if you are convicted of a crime, and pardons forgive you for a crime and release you from punishment. The president is also given the power to make treaties, which are agreements with other countries, and the power to appoint ambassadors who represent the United States to foreign countries. The president also has the veto power, but this power is mentioned in Article 1, not Article 2, because it pertains to Congress. Any bill that passes through Congress must be signed into law by the president. When a bill lands on the president's desk, he can sign it or veto it. Veto essentially means the president refuses to sign a bill. The president has 10 days to either sign or veto a bill. If the president does not act on a bill within 10 days, it automatically becomes a law. However, if Congress adjourns, which means ends their session before the 10 days is up, and the president does not sign it into law, it is automatically vetoed. This is called a pocket veto. Article 3 outlines the judicial branch, which is the law interpreting branch or the court system. Article 4 sets guidelines for the relationships between states. Article 4, Section 1 states, "Full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state." This is called the Full Faith and Credit Clause and means that every state should recognize the laws, records, and court decisions made by other states. For example, if you are a Georgia resident and you are taking a road trip and pass through Florida, Florida should recognize your driver's license, even though it was issued by the state of Georgia. Article 5 goes over the procedures for amending or changing the Constitution. To propose or suggest an amendment to the Constitution, either 2/3 of both the House and the Senate, or 2/3 of state conventions must feel it is necessary. Once they have proposed the amendment must be ratified or approved by 3/4 of state legislatures or 3/4 of state conventions. Article 6 goes over national debt, the Supremacy Clause, and the oaths of office. And last but not least, Article 7 goes over the procedures for ratifying or approving the Constitution. And in order for the Constitution to go into effect, it had to be approved by 9 of the 13 original states, which it was, and so it remains our Constitution to this day.